A last will and testament in Oregon in most cases can be a simple and straightforward document to make. Best of all, it can typically be drafted without seeking legal advice from an expensive attorney. In this video, we'll go over the importance of wills and what happens when one isn't made, what's included in wills, legal requirements in Oregon, and how and where to create an official will. Let's begin by briefly discussing wills and their importance. A last will and testament, simply known as a will, allows an individual to set instructions on how their property shall be distributed among family, friends, and other beneficiaries upon their death. It's an essential document for estate planning, and it's highly recommended for all adults to have one in place, particularly those who are elderly or challenged by life-threatening conditions. Now, what occurs if no will is left? A person who passes away without a will loses full control over who inherits their property. Instead, Oregon succession laws dictate how the deceased's assets are dispersed. It's common for the deceased spouse, children, or blood relatives to inherit the property by default in these cases. Leaving the property in the hands of the state may cause loved ones to contest the decisions made by the courts when distributing the estate, possibly leading to drawn-out court trials. Luckily, all instructions can be documented by making a clear will, and usually without an expensive attorney required. A person of sound mind can draft a will in Oregon with the following information on the document: their full name and residing address, the information of their personal representative, also known as the executor, who will distribute the assets accordingly, the names of all beneficiaries, and a thorough list of the property each shall receive, any additional terms and conditions, and the signatures of the testator and 2 witness signatures. And finally, let's review the legal requirements in Oregon. Last will and testaments in Oregon must be signed by the person to whom the will belongs, known as the testator, in the presence of at least 2 trusted, competent witnesses. Though optional, it's recommended that both witnesses be disinterested parties. Disinterested parties are individuals who do not stand to personally benefit from the will or receive a share of the testator's estate. The documents will be legally binding once all parties have signed. Multiple copies can be made and handed to trusted individuals for safekeeping. We're eForms, the biggest database of legal documents. We've created state-specific last will and testament templates specifically designed for Oregon that are quick and easy to fill out. Our software generates an official document after you select your desired will instructions and name all of your beneficiaries. Click on the link below to begin creating your will, and don't forget to like and subscribe for more daily videos.